great day for work here at the Happy Healthy Workplace podcast. I'm Kimberly Ficklin, your host. And every week we talk to professionals just like you all around the world because we want to find out what they do to create a profitable business, the kind of business where people really want to work. Today we're talking to Barbara Zabawa. Barbara is a national wellness lawyer with the Center for Health and Wellness Law, LLC. They're the go-to law firm for health and wellness industries. The center provides legal advice, resources, trainings, and advocacy to help health and wellness startups or existing companies operate in compliance. Barbara is going to share with us the laws around incentivizing your health and wellness program. In episode 1, I spoke with Misty DuPont from Key Knife, all about incentives in their wellness program. So now we get to learn how to make sure that we stay within the law when we're running these programs. But first, I'm going to kick this off with a case currently pending with Macy's. Okay, so currently Macy's and their third-party administrators are being sued by the Department of Labor. Among the allegations, they failed to properly apply the Reasonable Alternative Standard, RAS rules, allowing their smokers to avoid a health insurance surcharge. The important thing to note here is that Macy's did, in fact, offer their smokers a tobacco cessation program that would allow them to qualify for the tobacco-free health insurance rate. But cutting through all the complexities of the case, the program was allegedly non-compliant in 3 areas. Number 1, the availability of the RAS was not properly disclosed. Number 2, the smoking cessation program was unreasonably difficult for some individuals to complete for medical reasons, meaning that these people were not in fact offered a reasonable alternative given their particular circumstances. And number 3, the plan continued charging the tobacco surcharge to individuals who didn't remain tobacco-free for at least 6 consecutive months during the year, even though they had done the cessation program. Now, this is definitely a no-no if it's true. The whole purpose of the RAS is to allow certain employees to earn incentives or avoid surcharges even if they cannot achieve a particular health standard. It's also tricky and can be completely overwhelming. So we're going to ask Barbara how to avoid these types of instances. We're going to ask the expert. So Barbara, welcome.
Thank you. I'm glad to be here. And I'm glad you brought up the Macy's case because I find it interesting for 2 reasons. One, it's a huge company, and a lot of people might think, well, big companies like Macy's, they have it together. They know compliance. They probably have it all figured out. Well, here's a case where they didn't. A big company didn't have it all figured out. And 2, the law that issue is the Affordable Care Act or HIPAA non-discrimination rules, not what I'm usually talking about when we're talking about incentives, the Americans with Disabilities Act or the Genetic Information Non-Discrimination Act. It's actually those other laws, the ACA HIPAA rules that have been out since 2013 and been pretty stable. And yet we find ourselves looking at a case involving a huge company and a smoking cessation program that is out of compliance, at least according to the Department of Labor, with some very familiar rules. So I think that lesson is an important one in and of itself. A lot of people think that they have those rules all figured out, and especially if they work for big companies, that it's all, all kosher and they all, are in compliance. And here we have an example of that not being the case. So I think it's a really important case on that level as well.
Yeah, I definitely think it points out one of the reasons I was looking at this case specifically is, like you said, because it's a big corporation and you would think they'd have all their, T's crossed and I's dotted. But in fact, this is how easy it is for things to slip through if we're really not paying attention.
Exactly. And on a smoking cessation program too, which is not that innovative. I mean, smoking cessation programs have been around for a long time. And like I said, these rules have been around since 2013. And here we have a company that wasn't offering a sufficient reasonable alternative standard or not giving the incentive, the reward of employee completed the reasonable alternative standard. They still tying it to not smoking as earning the reward. And you can't do that under the HIPAA Affordable Care Act rules. You have to, if you have an outcomes-based program like this was, you have to allow someone to earn that same reward by having a reasonable alternative standard, even if they don't stop smoking. If they've done the alternative,
Yeah, and then it
You
didn't
have to
work for
give
them.
them the reward.
Right. And they're like, well,
um,
your program didn't work, but I should still get the award, right?
mhm.
Yeah,
And I
something.
think what might be at issue too is that they weren't allowing the employees to have their physician weigh in on what might be a reasonable alternative to earn the reward. So, that in an outcomes-based program, you have to allow that as another way for an employee to earn the reward, to involve their primary care physician.
What are some of the other
So,
things that you see? Like, this is pretty obvious. Like you said, it's a tobacco cessation program. This is no new program that's in and all this, and nobody knows the rules. So what are some of the other things that you see that are almost like they are just glaringly out there that people are making the mistake and maybe are unaware of?
yeah, so where a lot of the issues arise is when companies are tying rewards to employees giving up health information, usually through a health risk assessment or a biometric screen.
Mm-hmm.
And the EEOC, the Equal Employment Opportunity Commission, the federal agency that enforces the ADA, Americans with Disabilities Act, and GINA, Genetic Information Non-Discrimination Act, had come out with rules saying, if you're going to collect employee health information or employee family member health information, and you want to tie a reward to them giving up that information, you have to provide them notice, and you can't have that information be required. It has to be part of a voluntary wellness program.
Mm-hmm.
And why this was important is they were trying to balance an employee's need for privacy. Health information is sensitive, and employees may be hesitant to give up their information. So if an employee wants to give up their information, it has to be a voluntary choice for them to do it.
Mm-hmm.
So when you start incentivizing employees to give up their health information, that whole voluntary question comes up. Are they really giving up their information voluntarily for this reward? Is the reward so big that it really isn't a voluntary act anymore? It's, food on the table or gas in their car. They give up their health information. And that's where a lot of these concerns about the EEOC back in 2016 published some final rules and said, okay, we will consider any reward up to 30% of the total cost of coverage. So the value of the reward, as long as it didn't exceed 30% of the total cost of self-only coverage, and there were some ways that you could calculate that would not undermine the voluntary nature of an employee giving up their health information in exchange for that reward. Well, the AARP, American Association of Retired Persons, sued the EEOC back in 2016, a few months after they came out with the rules, and said, hey, 30% of the total cost of self-only coverage, that's a lot of money for a lot of people, especially people with disabilities who often tend to be on the low income side of things. So we don't think that 30% qualifies as a voluntary choice of giving up health information. We don't know where you got that number, and we think it's too high. And the court, they sued, in the District Court of the District of Columbia agreed with the AARP and said, yeah, that 30% seems a bit arbitrary. So the court asked the EEOC to get rid of it and replace it with something else. So they did get rid of it as of January 1st of this year. So now employers are kind of stuck with some gray areas and not sure what amount of incentive would still qualify as a voluntary act for employees to give up their health information. Next month in June, there's supposed to be some proposed guidance issued by the EEOC that might give us a look into what they might consider an alternative number, probably less than 30%. My guess is it'll be less than 20% if we're using cost of self-only coverage benchmark. But at the end of the day, the law says, the statute of the Americans with Disabilities Act and GINA says that the giving up of health information has to be voluntary. So any incentive that employers tie to that act, giving up health information through an HRA or biometric screen, has to be a voluntary act. And so that's what employers have to work with when they're designing their programs. And that's tricky because it's subjective. one person might think an amount of incentive is a voluntary act, and another person might think that's too much. I don't have a choice. I can't pass something like that up. So it's going to vary by employees, which makes it difficult when offering incentives to employee information gathering.
So is that the only type of incentives that are tricky tied to that, health information, or is it kind of all across the board? Because one conversation that I've had before is, so my husband at his work, they offer health incentives in that, if you go to certain health classes or whatever, you can do these certain things and get like 25% discount off your rate. But I've had conversations where we've talked about that seems to be also discriminatory, because if the classes and or the programs that you're voluntarily going through are ones that you can't maybe get to, or maybe they expect you to go to the gym, but you have a disability, like you said, you know what I mean? And that these certain things tie to that, kind of like the reasonable alternative standard, where do these other people need to be offered something different to also qualify for that incentive? Does that make sense what I'm saying?
Yeah, it makes absolute sense. And yes, there is another provision of the Act that would come into play here in some of the situations you were describing. So one requirement that all employers have to abide by under the ADA is a reasonable accommodation requirement. The EEOC has said that workplace wellness programs are a benefit of employment. And the ADA, its primary function is to make sure that all employees, regardless of ability, physical or mental, have equal opportunity to enjoy the benefits of the workplace. So if you are offering a wellness program and an incentive to, attend a class or an activity that someone with physical or maybe mental limitations can't participate in, then it's incumbent upon the employer to offer a reasonable accommodation to that employee so that they can too enjoy that benefit and reward that goes along with it.
That was my thinking, because I mean, even something as simple as, because this workplace does this all the time, is a walking challenge, right? So now we're going to have this big walking challenge. We're going to encourage everybody to do it, and we're going to incentivize them by giving them something, right? And but yet there may be somebody whose limitations don't allow them to be a part of that walking challenge. Now they have no opportunity to be incentivized to do anything, right? And there is no, like when you're somebody at the gym, they show you, oh, here's how you do the exercise, here's the modified version, right? And then there's no modified version.
Right. And so one could argue that, violating the reasonable accommodation requirement under the ADA. Mm-hmm. And, when you start asking for diet challenges and tying rewards to that, and maybe you're not asking anyone to fill out a survey or a questionnaire before starting the diet challenge to see if it's even a good idea, for them physically to participate, which is another issue. I mean, another risk, a legal risk, if you aren't having employees before participating in some of these fitness or diet challenges, disclosing some possible risk areas. For example, maybe they're pregnant, or maybe, they are on medications, and this particular activity would be a very bad idea for them to participate in. If you're not asking those questions, and again, you probably should be for other reasons, you could be leaving out individuals who can't participate because they are pregnant. Mm-hmm. And now you're discriminating against someone's gender. You're invoking another law, Title VII of the Civil Rights Act, which protects, discrimination based on gender and race and national origin and other things. But in this case, pregnancy would be gender. And so, having those kinds of challenges without thinking about how other people in different situations, if physical or mental, might be limited to participating in that is risky, legally risky. So having a compliance evaluation of those kinds of programs, not just the health information collection, but any of the activities, to make sure there's not going to be some inadvertent discriminatory treatment is a good idea.
So in all reality, Barbara, I'm getting ready to throw out this walking challenge because it sounds like a fun thing to do and everybody's doing it, right? Like every HR director I know is throwing in a walking challenge. And to me, this seems like just a small thing, right? We're just going to do this walking challenge. I mean, how does an employer decide, well, I better check compliance first? You know what I mean? I'm sure that's not happening. They're just thinking
I'm
this is such a
not.
easy thing, right? Like, oh, it's nothing. It's just a walking challenge. I don't need to worry about anything. But I mean, so what can an employer do with every challenge that has to do with health? And I don't just mean like putting in a challenge, but I mean literally program challenges and that. With all of that, how should an employer find those compliance issues? How would they do that?
Well, I mean, it has to be a cultural shift in the world of workplace wellness and accepting that compliance is part of the calculus whenever you're coming up with a new wellness idea. Just like, anytime healthcare, there's discussion about sharing information, patient information, the culture has shifted since HIPAA came on board, HIPAA privacy and security, that as an automatic, okay, before, we share this information, we better check that it, compliant with HIPAA privacy and security standards. I mean, that's just the mindset. And I think we need to have some kind of shift like that in wellness just to make sure we're as inclusive as possible, because that's what it comes down to. It's a great idea, yes, and it's a good way to build community and in the workplace, but that's just it. I mean, what about all the other people? I mean, this is especially true for larger workplaces. If you know everybody, you work for a company that maybe has less than 20 employees and everybody knows everyone, it may be a completely different issue. But if you have a large employee population and you don't know all the limitations of your entire employee population, you need to be considerate of, that there may be people with limitations. And especially if you're tying incentives, then that challenge becomes even more of a benefit that everyone should be able to participate in.
Mm-hmm. So I'm the HR director or whoever, the safety director, and I've just been told we're going to do this thing and I'm in control of it, or I'm leading this. I should be talking with whom before I put this together?
Well, I mean, if you have a legal department in your company, start with them, of course. Otherwise, there are, Co-op, for example, is a great resource. And, firms like mine are a good resource. But, I mean, there are other ways to maybe check that you're not missing something. It's just a good idea not to miss something. Because what I want to impress on, your listeners is compliance is not just something that you should be fearful of or dreading that you have to do, but I think that if you embrace compliance, you're going to have a better program because it's going to be more inclusive.
Yeah, absolutely. And and you're not going to get in trouble for something that you're even unaware that you're doing, right?
Exactly.
Yeah,
exactly.
That it's such a great conversation because strategizing, like we had discussed before we got on the call, going in and doing an internal audit and talking about strategies for well-being and culture, a compliance evaluation certainly should be one of those things that are being done during that time frame, right?
Exactly. I do that for clients all the time, and it's even the most meticulous clients who have really poured over their program and felt like they've got all their I's dotted and T's crossed. There's usually something that they can improve upon. There could be this stray question in an HRA, for example, that is really asking for genetic information. And, now we have to worry about Gina. And it seems like an innocent question, and yet it triggers another law that they didn't think was even applicable to them. So it's just a good idea to have that comfort, because if you can say with confidence that, yes, we've looked at our wellness program and we have evaluated it for compliance with all these different laws, and it's more than just the ones we usually talk about, like HIPAA, ACA, ADA, and GINA. There are lots of other laws. If you can say that to your employees, they're going to feel, I think, a lot better about your program, and that it's a really well-designed program. And it's also something that you can tout externally. It's like, we have really looked at our program and made sure that it is compliant, and that's gonna generate a lot of positive interest in your program.
Yeah, I think it speaks to the employee that we've taken the time, the care, the attention to detail. This is a big deal to us, so we really did it right for you. I think that's really important. And also, going back to the inclusiveness is that if everybody feels like they can be involved, then it's going to be a more successful program. And the statistics when people are like, oh, wellness programs and, you get 25% participation. And I would say, look at your employees as a whole. How many can't even be a part of your program, right? So you're basing the statistic off of, I have X amount of employees and, that work here in house and X amount of employees show up for the wellness program. Mm-hmm. And so then therefore that's our success with a wellness program. It is either that or not. And really all you're doing is you're designing a wellness program for probably already healthy employees or somewhat already healthy employees, right? They're the ones that are jumping in like, yeah, because that's their lifestyle. So you've got those 25% that are, go-getters and they're going to jump in and do it. And maybe some that like the incentive, but that statistic is really flawed because you're not taking your workplace as a whole.
Right. And the law really, those discrimination laws that I talked about, Title VII, ADA, the whole point behind those laws is to make sure that those employees who those laws protect feel, like they're included, that they're, they have the equal opportunity to participate in the workplace. And it doesn't matter about the protected class status that they have, that they're still able to fully enjoy the benefits of their job. Mm-hmm. And so, keeping that in mind when you're designing programs is, I think, really important. And then, you're in a much better position should someone ever complain about your program as being discriminatory. If you've gone through that exercise of evaluating, the person who wants to complain is going to have a much tougher time in succeeding in that claim. But I think the whole point of going through that exercise is that you shouldn't see any complaints. If it's truly inclusive, I think you're not going to have a problem with people feeling like they're being left out.
Yeah. That's so true. And, it happens even in the smallest of things. We're talking about big programs. We're talking about, legalities and things. But I go back to my husband at his previous job. There was a group of people that like to get together and play games, board games out at lunch. And it created this community. It was really neat, actually. And they became friends and they started doing things outside. But what was happening was these were the salaried employees and they got an hour lunch. So they had time to sit down and play a game. Well, the manufacturing floor did not have the same time frame. They had a 30-minute lunch and they had to clock in and clock out, right? And so there was complaints coming up to HR saying, first of all, that these people were spending a lot more time at lunch than they should have, right? So it's over an hour. Well, nobody's really paying attention, but they're really they're seeing them there, right? As each 30-minute person's coming in and out, they're probably going back to the floor and having that conversation. And I know my husband and I talked about it because he was like, man, they're telling us we can't do that anymore. And it was really great because it built this community. It did all this. And we had that conversation about inclusivity, and that everybody has to be able to have that space. And so if you can't give it to the people who are on the manufacturing floor, then unfortunately you have to stop it from happening with the salaried employees as well.
Yeah, and, I think that's a great example of how a lot of lawsuits happen. Is usually it's from someone who feels left out of something, an employee who feels like they were shortchanged in some way, and they're the ones who alert the government to a possible claim. That's how it usually happens. So, having an inclusive wellness program or whatever other type of community building activity is important, not only for, the success of the program, but also it mitigates potential lawsuit that might arise, because that is how it typically happens. Someone feels like they were cheated in some way and they complain to the government. So being aware of that's how a lot of these legal issues come up and come to the attention of the government can help you look at your programming, your activities through a better lens, making sure that, are we upsetting a contingent of employees who can't do this? For whatever reason. And is this increasing our legal risk by having this designed this way?
Yeah, that brings up another thought of inclusivity is because a lot of companies have different divisions that are off-site and they do a lot of their wellness program on-prem, right? So now it's how do we push that out to divisions and have them be involved in a way that makes them feel, well, like they're involved, right? And not that we put this program together on-prem and anybody who works outside of that is really not a part of it.
Yeah, and the law has some built-in ways that you can accommodate different off-site geographic locations of a large company like that. I mean, the Affordable Care Act wellness rules allow for employers to offer different wellness programming, essentially, for employees who are located in different geographic locations. That is not discriminatory, according to the Affordable Care Act. You can, as long as it's a bona fide employee classification, and different geographic locations usually is a bona fide employee classification, just like part-time versus full-time type of classification, you can, have different programs to fit within those different geographic locations, because the needs may be very different between different geographic locations.
Very true, because that is absolutely a conversation to be had as well, because what we do here in America isn't necessarily what is done in another country, and or not only that, but even the resources are different. And so you have to be having that conversation in that community, right? Like you have to build, each community would be built just a bit separate, each program, because of wherever they are in the world. Well, this was a great conversation to have, Barbara. So in closing, is there anything that you think needed to be said that we didn't say today?
I just think it's really important for everyone to pay attention to June next month to see what the EEOC is going to say about the wellness program incentive rule. So keep your eyes and ears open for that, and to make sure that you have compliance as part of your program design, because the law, believe it or not, can be very helpful in helping you design a more inclusive and successful program.
Yes, I love that. That is a wonderful thought. And we'll have to have you back on to chat with us again in June after they update the law. We can have a conversation about, what happened and what it means for us. Sound good?
Sounds great.
Wonderful.
Thank you, Kim.
Thank you, Barbara, so much for being on with us today. This is really important information for employers to know so that they can really start a nice, robust, and inclusive well-being and culture program and be on the side of law so that it continues to run smoothly and they don't have anything to worry about. They can be confident with it. So that was our talk with Barbara today, and we look forward to hearing from her again in June. That's a wrap for today. The Happy Healthy Workplace podcast is now complete. Be sure to subscribe and join us weekly for secrets, solutions, or strategies that help you create a profitable business where people really want to work. This is Kimberly Ficklin, wishing you a happy, healthy day.